Hi, everyone. Welcome. Just giving folks a few more minutes here. I'm seeing some people filtering into the webinar room. Thank you all so much for joining us on this Wednesday afternoon or morning, depending on where you are in the country. I think I see things slowing down. Okay. All right. Well, I think I'm going to get started, and we'll keep letting folks in as they filter in. But thank you all so much for joining us today. This is our second webinar that we've done on this topic. We had to break the webinar into two different presentations, just given the demand on this topic. So thank you all for bearing with us and joining us today. And today we're going to talk about what you need to know if the Department of Labor revokes the Fair Labor Standards Act home care rule. And depending on how long you've been following this topic, you may recall back in 2013, the Department of Labor under the Obama administration issued this very ambitious new guidance that changed the federal interpretation of the Fair Labor Standards Act as it applied to workers in what Department of Labor calls home care. I don't love that term, but that is the term that you're going to see if you're reading about this rule. So we're going to use it today, but they're really talking about the broad range of services and supports based in the home and community for people with disabilities and people who need support services. All right, so I will jump in here, assuming everyone can see my screen. And so we have a lot for today, and I apologize in advance for having a lot of text on these slides, but there's just a lot of information to get through, and we wanted folks to have access to all the different citations and all the different cases and all of that stuff. So again, I apologize in advance for a whole lot of text, but we wanted to leave you with as much information as possible, and you will get a copy of these slides as well as a recording of this presentation will be sent out after the presentation finishes up. So today we'll talk about the new proposed rule change from the Trump Department of Labor that would reverse the Obama Department of Labor's initial rule change on this topic. And we'll go into all the different history and context of the original home care rule and what's going to change potentially if this proposed rule change does move forward, which we think it will. One thing that I want to talk a lot about today that I think is important is we're going to talk about how this rule change could stick across administrations. So if you'd followed some of the other Department of Labor rule changes, some of them, what you will often see is that a Democratic DOL will put in a rule change, and then a Republican DOL will reverse that and then issue their own rule change, and then the cycle just continues across different administrations. And thanks to what's been happening at the Supreme Court, I think this one is a little bit different, and I think this rule change could be more permanent than most of the others that we've seen from Department of Labor recently in this space. So we'll talk about all that, and then we'll also talk about submitting formal comments to DOL and how you can do that if you have thoughts on this rule and would like to represent your organization. And then we will have some time for Q&A, and we'll see how much we need. So what just happened is that earlier this month, right before the July 4th holiday, and this is a theme with federal agencies, they love to announce big rule changes just before a holiday day, in this case, 4th of July. So the Department of Labor issued what's called an NPRM, a Notice of Proposed Rulemaking. And that proposes to eliminate the kind of Fair Labor Standards Act home care final rule that we had from the Obama administration. It was one of the kind of signature achievements of the Obama administration. And if you're interested in reading the full text of this new Notice of Proposed Rulemaking, this NPRM, it's available here at this link. And remember, those slides will be sent out. And DOL essentially said, they said, look, we think the Obama era home care rule made services more expensive. We don't find evidence that it increased take-home pay for workers in a meaningful way. It did not improve worker turnover rates. And they also argued a little bit more kind of legalistically that they don't feel it best reflects congressional intent behind the original Fair Labor Standards Act. So that's sort of the rationale here. And we'll dig into this a little bit more deeply shortly. So what this rule change would do, if DOL moves forward with it, which we think they will, What would happen is that the law would revert back to older regulations in the home care space that date back to 1975. And the 1975 regulations are much less strict than the 2013 home care rule. I tried to, we were sitting around the office kind of trying to come up with scenarios in which you could be compliant in the 1970, excuse me, if you could be compliant in the 2013 regs, but not be compliant under the 1975 regs. And I don't think there's any such scenario. We really tried hard to come up with one. So essentially the 1975 rules are much, much, much looser than the 2013 home care rule. And so I think the big piece here is that most workers in self-direction will again be legally classified as companions under the 1975 regulations. And what a companion is, this is a really special, kind of tightly defined word for Department of Labor purposes. The Department of Labor says, or used to say before 2013, is that a companion is exempt from federal minimum wage and overtime requirements because the Fair Labor Standards Act governs minimum wage and overtime requirements at the federal level. Now, with that said, state law still applies. So there are some states that have very rigorous state labor laws. So even if you're a companion who is exempt from the federal minimum wage and overtime rules, you may still be covered under your state law. So that's definitely something to look into if you're not familiar with your state law. But this is kind of the biggest change here is that most workers in home and community-based services would be reclassified as companions. And as companions, they would not be subject to minimum wage and overtime protections at the federal level. Now, third-party employers, and this is a term you may remember if you followed this years and years ago, DOL has this term that they call third-party employers. And a third-party employer is really anybody except the participant and their household who is employing a worker. So a third-party employer might be like a home care agency, for example. Third-party employers could again use the companionship exemption from minimum wage and overtime. They could also use the live-in exemption from overtime. So one of the big big pillars of the 2013 home care rule was DOL said, look, third-party employers, they're professional businesses. They need to be paying minimum wage and overtime just like any other business in any other industry. They can't take the companionship exemption. They can't take the live-in exemption. But what this rule would do is it would revert back to 1975 in which agencies could use those exemptions kind of at their discretion. But what all this means for self-direction, if DOL does indeed move forward with this rule change as they describe it in the NPRM, number one, programs that cap worker hours at 40 per week, or another number, but we know there are a lot of states out there that where their current policy is to cap worker hours at 40 per week. Workers are not permitted to work overtime. Might consider lifting those caps because workers, if this rule goes forward, workers will no longer be legally required to be paid overtime at least at the federal level. Now, some states, they may still be owed overtime under state law, but in a lot of states, once that federal protection goes away, workers will not be legally owed overtime. Can programs still pay overtime? Absolutely. There's never a penalty for paying more than what the law requires, but there are penalties for paying less. But in this case, workers would not be subject to overtime requirements. So I think that's one way, and we've certainly heard from workers who were impacted by the 2013 rule change that they maybe used to work 48 hours or 60 hours or whatever the case may be in the program, and then their hours got cut back to 40 because of the new overtime requirements. So that's one thing where we might see, I think, changes that would be, for the most part, kind of budget neutral for payers, because if you lifted the hours caps, you would not necessarily be owing any overtime premium. It would still just be straight time in terms of what the law required. Number two, programs that currently pay overtime or paid travel time, we'll talk about travel time more in a second, would no longer be federally required to do so. So we know there are some programs that coughed up more money for overtime, for travel time, coming out of the 2013 home care rule. So that, of course, they could absolutely keep doing that, but there wouldn't be a federal requirement to do so. So that's a place where we're expecting to potentially see some changes and some adjustments if this rule does move forward. Number three, I think, is the big one, and we'll talk about this quite a bit in the rest of the presentation, is that we won't have to think as much about joint employment under the FLSA. And if you've been with us for the last 10 years, there's been a lot of talk about joint employment and am I a joint employer and what is this all about? And we will go into kind of why that became so important in the wake of the 2013 home care rule and why it won't be so much of a kind of legal concern going forward if this rule does change. And one, I think, big reason for that is that the risk of litigation related to FLSA joint employment will be greatly reduced. And again, we'll talk about kind of the drivers of this, but these are the outcomes that, if I was a betting person, which I'm not, these are the outcomes that I might kind of bet on in terms of changes we might see in these programs. So I'll move us forward here. So I'm going to roll us back to 2013. So, if this was a TV show or something, this would be sort of the, previously on, and it goes back to the previous season and brings you up to speed on everything that happened so that you can, just again, be refreshed on what's happening in this episode. So that's sort of where we are right now. We're going to go back to 2013 and talk about all these changes and then, kind of look at how they might be changing going forward here in 2025. So the 2013 home care final rule, I've talked about this a little bit, but what it really did was that the rule redefined the term companionship. And we talked about the term companionship, about how DOL defines that. It does not mean that you're receiving companion services in a Medicaid program, for example. The Department of Labor defines companion as, people that are providing kind of support services in the home. And the DOL back in 2013 really narrowed the use of the companionship exemption. And they narrowed it so much that really no workers in self-direction or any sort of HCBS program really qualified. And that was very much intentional on their part. They couldn't just get rid of the companionship exemption, but they wanted to make it so narrow that very few workers would ever qualify. And that was intentional because they wanted workers covered under minimum wage and overtime protections. So that was the first big change that the rule made back in 2013. The 2013 rule also prevented what are called third-party employers, and that's anyone other than the participant in their household, from using the companionship exemption from minimum wage and overtime or the live-in exemption from overtime. So even if the worker was a companion, DOL said, okay, if you're a home care agency, a for-profit company, you cannot use these exemptions. You have to pay at least minimum wage and overtime like any other business in any other industry. So those were the two kind of pillars of the home care final rule back in 2013. And what this did by doing so is that suddenly we started really worrying about joint employment under the Fair Labor Standards Act. And you might say, hey, but hold on, nothing you just said in that previous slide had anything to do with joint employment. Why are we worried about joint employment? Well, suddenly, since workers were covered under minimum wage and overtime rules, we needed to know for the first time whether a worker had one or many employers under the FLSA. So it's important for context here to realize that the Department of Labor uses a totally different test of employment than, for example, the IRS and most other government agencies. So DOL has this really unique, strange test of employment. So from DOL's perspective, if you are if you have any substantive control over a worker's work conditions, their schedule, who's being hired, you are likely an employer for purposes of the Fair Labor Standards Act only. Now, the IRS, for example, most government agencies, they only recognize one employer per employment relationship. But DOL could look at that same employment relationship and say, nope, there's actually 2 or 3 cooks in the kitchen here, and they are joint employers of this person. And it really depends on kind of the economic realities of that employment relationship. So just keep in mind, the thing to take away here is that DOL has this very strange test of employment. And so suddenly, when you take into, for example, a self-direction program where maybe the participant is hiring somebody and the FMS is doing certain things, and then the state has certain rules for the program, it starts to look like, oh, maybe it's not just the participant here for this very broad, expansive DOL employment test. Maybe we have multiple employers involved. And you might say, okay, well, why did that matter? Well, we can look at it. So if we look at a kind of sample employment relationship with no joint employment, for example, in a self-directed context, it might look like this. Okay, so we have Wendy, who's a worker in the program, and Wendy works for Peter, who's a participant in the program. So Wendy works for Peter for 25 hours every week. Wendy also works for a different participant in the program, Piper, also works 25 hours per week. So if there's no joint employment under the FLSA, Wendy works 50 total hours per week. She has 2 separate jobs. So this is exactly the same as, for example, Wendy working 25 hours a week at Target and 25 hours a week at Walmart. Walmart doesn't care what hours she works at Target, vice versa. They don't care. They're 2 separate jobs. She does not get any overtime because she has, again, 2 separate jobs. Wendy never directed her to work overtime, or excuse me, Peter never directed Wendy to work overtime. Piper never directed Wendy to work overtime. So no overtime is due, no travel time is due. But if you take this same example, we have Wendy, she's working the same hours for Peter, 25 hours per week. She's working 25 hours a week for Piper, but we add a joint employer. For example, let's say the state is a joint employer along with each program participant in this self-direction program. What happens? Suddenly, the legal requirements are very different and the cost is very different. So what ends up happening is, again, Wendy's still working 50 total hours per week, but the state is a joint employer. So what that means for the Department of Labor purposes is that Wendy has one job. She's working for the state, and the state is jointly employing her along with each participant. So she worked 50 hours for the state that week. So that means 10 hours of overtime is due. It can't come out of Peter's budget because Peter didn't direct her to work overtime. Can't come out of Piper's budget because Piper didn't direct her to work overtime. And then the state would also have to pay Wendy for any travel time that she spent, for example, traveling from working for Peter to working for Piper or vice versa, because DOL would see that as, for example, going to one office of the business to another. So you can see how the same employment kind of scenario looks very different and the cost is very different depending on whether or not there is joint employment. It's not that joint employment is a bad thing, but if there is a joint employer in the program, you need to know and you need to be prepared as far as budgeting, as far as funding, making sure that there's tracking for all of this. And so as you can imagine, this was really where we spent a lot of time. It wasn't that big of a lift to make sure that all the programs were paying at least minimum wage. Even overtime was manageable, but it was this joint employer piece that suddenly became so challenging for us in the self-direction world. And we simply didn't have to think about it before the 2013 home care rule came out, because workers like Wendy were never legally owed minimum wage or overtime to begin with. They were considered companions. And suddenly Wendy was no longer considered a companion. And suddenly Wendy was owed minimum wage, owed overtime, and we had to kind of grapple with all of this stuff. Who's a joint employer? Who's not a joint employer? So it was a very very busy time for us, and I think it did create some uncertainty and some stress for providers and payers in the self-direction space, and also participants who are getting notices in the mail saying your worker can only work 40 hours now. They can't work more than 40 hours in the program, because there was a lot of that had to go out when state legislatures wouldn't increase funding for these programs to cover these new expenses. So, I think states struggled with implementing this 2013 home care rule. That's according to some formal research on it. Applied Self-Direction was involved in that research. We were one of the data collectors, and you can read the full report if you're interested in kind of reading about how it was going in terms of implementing this rule. Some states acknowledged themselves as joint employers in the wake of the rule, and they implemented systems to track and pay third-party overtime and travel time. That did happen, but it was not kind of the common response. It was more frequent for states to just set caps on hours worked, or they delegated this to their MCOs to limit or eliminate overtime worked in the program. And this happened a lot because, again, this rule was kind of an unfunded mandate where suddenly you had to pay all this overtime where you didn't before. And not all states had the budget flexibility to be able to accommodate that new cost. And so we had a lot of, again, 40-hour a week caps being put into place to eliminate overtime. Unfortunately, a few states even eliminated their self-direction programs entirely. This happened largely because DOL did, as part of its enforcement of this rule, send letters to a couple states saying, hey, we think you're a joint employer and we think you're not paying overtime. And, if you don't make changes and start paying overtime, you can expect an enforcement action. And, if the states didn't have the money to come into compliance, they just got rid of the programs. It was really, really unfortunate. And then as some of you know, I know some of you on the call today are following this. There's also been kind of major litigation at kind of the class action level. For FLSA litigation, it's actually called collective action, but there's been this major litigation representing huge swaths of workers trying to portray the financial management services providers as joint employers in these programs. So this has gone on for years, and for the most part, these cases have been unsuccessful. Courts have pretty consistently found that FMS providers do not act as joint employers under the FLSA. But this is something where I think there's a lot of, I think, political money involved in these cases because, it's certainly, I would say, labor advocates want more joint employment. They want more funding for these programs. And of course, we all want more funding for these programs, but it's been, I think, very stressful for the FMS industry dealing with these lawsuits when they're just kind of following their contract requirements. So those are just some of the things that have happened when this rule had kind of a destabilizing impact, I would say, on self-direction and really the HCBS ecosystem more broadly. So looking ahead, so that was sort of the 2013 rule and its aftermath and what happened. And 10 plus years later, we are for the most part really in compliance with the rule, and different states and different MCOs reached that compliance in different ways. Different providers had different strategies, but here we are. And this really, we knew the Trump administration was looking at the home care rule. They had confirmed that, but we didn't know this NPRM was coming. They kept that pretty close to the vest. But we, feel that it's likely DOL is going to move forward with this rule change. Right now, it's just proposed. They have to seek feedback and get public comment and respond to it and all of that stuff. But I really think it's this guy whose picture you see here, Jonathan Berry. He is the administration's nominee for DOL solicitor. And the DOL solicitor is the top attorney at DOL, almost like the attorney general of DOL. But before he was in government, he represented the home care industry. So he was actually representing the agencies against the Democratic DOL in major litigation that focused on the home care rule. So the top lawyer at DOL knows the home care rule inside and out. He's spent years fighting it. So I think he's the one that really is pushing this forward. And the timing of this NPRM indicates that this is going to be pushed forward before the next presidential election. So I think this is something, if I were a betting person, I would bet for the Obama home care rule to go away before 2028. So as I mentioned before, you could say, okay, great, it's going away, but we're used to a lot of back and forth where one administration takes away a rule and then the next administration brings it back and yada yada. And so that has been going on, but I think bringing back the home care rule is going to be an unusually tough battle legally. And if you remember back in 2013, once this rule first came out, there was a lot of legal scrutiny. There was some litigation. The big case ended up being this case I've included here. It's called Home Care Association v. Weil. David Weil was the wage and hour administrator for the Department of Labor. And the Home Care Association sued, saying, you as a federal agency have gone too far. You are acting, you are creating law like Congress does. We can't, you have exceeded your authority as a federal agency. That was really the basis of the lawsuit. And initially, the judge struck that down. So the judge agreed with the Home Care Association and said, "You've gone too far. This is too ambitious." But then it was appealed, and the DC Court of Appeals, which is the second highest court in the land, reinstated it. And the DC Court of Appeals said, "Hey, we actually think this is legal. So the rule stands for now." It got appealed again to the Supreme Court, but the Supreme Court says we're not going to hear this. So that means the DC Court of Appeals decision stands. And if you read the DC Court of Appeals decision, I promise I'm getting somewhere with all of this. The DC Court of Appeals determined its ruling using what is known as the Chevron doctrine. And it is this legal doctrine that was out there for many, many years. And it meant that, if you're a court that's reviewing the action of a federal agency, reviewing a regulation, you really should defer to the federal agency's interpretation of a law that they administer. Unless the law says exactly how it needs to be administered, you need to trust the federal agency. And so that was the Chevron doctrine. And so that's what happened here, where the DC Court of Appeals said, okay, we are trusting the federal agency that is administering the FLSA. And we find that this is essentially within their authority, and it can stand. The whole key to all of this is that last year, the Supreme Court struck down the Chevron doctrine. And so that ended the era where courts had to kind of defer to federal agencies unless there was something flagrantly wrong. So there's this court case here. If you're interested, if you get into the legal drama, which hopefully you have better things to do with your time, but I don't. And so there was a case last year, it reversed the court's decision. And so now we don't have the Chevron doctrine. And if you remember, the whole home care rule depended on the Chevron doctrine to be found legal. So I think if there was another court case, if let's say the next Democratic administration brought back the home care rule, it would go to court again, but the whole basis by which it was found to be legal is gone. So it's going to be a lot harder to bring this back. It's going to be more likely that a home care rule replacement would break down in court. And so I think, the Trump administration absolutely knew this, and that's why they picked this time with the new Supreme Court change to get rid of this regulation that they didn't like from the Obama era. So that's where we are, and that's why, if I were a betting person, I think, it's more likely that this rule change, if it moves forward, is going to move forward, and the home care rule is unlikely to come back in anything that looks like what it did back in 2013. It's going to be much harder to get that to stick legally. So you listen to all this and you're like, okay, what do I need to do to prepare for compliance? As I mentioned before, if your organization has been working to comply with the 2013 home care rule, you probably don't need to do anything else for now, as far as, liability under the FLSA. So for the most part, workers in self-direction and the HCBS space, with exceptions like nursing and more licensed type work, are going, all the other workers that are, not licensed, that are not doing kind of skilled tasks that would require formal training, will be considered companions if this rule change moves forward, and they will not be owed minimum wage or overtime at the federal level. The NPRM does not propose adding any new obligations for employers. This is simply a rule rollback. It does not add anything in its place. There's no new requirement, for example. So I don't think there's a ton for us to do here other than watch and wait. And I think, if you're a payer, talk to your providers that you're working with. If you're a provider, talk with your payers, and just see what policies might need to be adjusted if this does move forward. I think the key takeaways, number one, thanks for bearing with me through all that text and all that kind of legal context. Number one, the home care rule from the Obama days is likely going away in its entirety. There will not be any brand new rules to replace it as far as we know. The Trump administration did not announce any in this NPRM. But we'll see what happens in public comment. If DOL does move forward with this proposed change, the country is going to go back to the 1975 regulations regarding the companionship exemption and the live-in exemption from overtime for workers who live in with the person who's receiving services. Most workers in self-direction, again, will be considered companions. They are not subject to federal minimum wage or overtime rules. Again, check your state, because there's been a lot of movement at the state level, particularly in kind of bluer, more democratic states recently. And I think the final takeaway that's really big for stakeholders in self-direction is that we are not going to see FLSA joint employment continuing to be this big compliance concern, this big source of instability. And that's, unfortunately, that's because the workers will not be legally owed overtime or travel time under the FLSA. They may still be subject to it under state rules, but they won't under the federal rules. And yes, again, check labor law in your states. You can read the laws in your state, but also, just keep in mind that even the Fair Labor Standards Act is administered differently in different parts of the country. So even the federal side can be a little bit stricter depending on where you are. But again, what this rule is doing is really taking a huge class of workers out of FLSA protections, which I don't think it's going to ease the workforce crisis in any way. I mean, obviously, it's workers should be subject to minimum wage and overtime if we expect to have a healthy workforce. But at the same time, I would not be surprised if some workers that are currently working 40 hours can suddenly pick up more hours under state policies that I think will change, knowing that states will not have to be paying overtime in a lot of the country. If you'd like to submit comments to DOL on this, we have the link here. Again, you will get these slides. We are planning to submit comments on behalf of Applied Self-Direction, and we will be sharing our comments for member review prior to submission. We are continuing to have conversations with members all over the country on this, trying to get a sense of perspectives and what's out there. We do know that the volume of comments that they receive is very important to federal agencies. When they're looking at comments received, they often do, how many comments say that they strongly support, how many comments say that they strongly disapprove, that kind of thing. So we really encourage you to submit your own. You are welcome to use ours as a template if you'd like, if you agree. But we certainly encourage you not to hold back with DOL, because I think it's very important for them to hear from people in this space, and particularly self-direction stakeholders. So comments will be open until September 2nd at 11:59 p.m. And at that point, we'll see what the department has next. So we now have time for Q&A. And if you have any questions, now's the time to share them. We'd also love to hear what your thoughts are on this proposed change, if you have any. And also, if you prefer to connect with us one-on-one and rather than a public webinar, we'd be happy to connect with you as well. You can reach out at any point at membership@appliedselfdirection.com. So let's see, Applied Self-Direction staff, I'll turn it over to you because I can't see the questions right now.
There currently aren't any. So if you,
Oh, wow.
Yeah, comments or questions. Let's see. Oh, one just came up. Let's see. Are you able to speak about how this would impact New York? They don't have participants as employers and only the FMS is.
Yes. So in that case, let's see, I would need to check New York's labor law. I would assume New York has a stricter labor law. And Laura, I know you're on the line. If you happen to know off the top of your head, I know you've done more work in New York recently than I have. But in terms of what this would look like is that the single statewide FI would be subject to state law only for labor law compliance. So whatever the state law would say, and I believe New York has the Domestic Workers Bill of Rights and some of that stuff, whatever state law says would govern for the most part, because at this point, most of, if not all, workers in CEPAP will, for federal purposes, be classified as companions and therefore not subject to federal minimum wage or overtime.
Thanks. And another question came through. What will this mean for live-in caregivers and self-directed programs like parents? Will this drive down wages?
This is a great question. And one of the aims of the 2013 home care rule was to drive up wages. And we did link some formal research that looked at state responses to this rule that we assisted with. And that research really did not find that wages increased, because what ended up happening was that even though workers were supposed to get paid more, many states they kind of had their hands tied and had to instead just limit overtime or ban overtime entirely. And so what we found in the wake of the 2013 home care rule, with some exceptions, is that in general, worker wages either flatlined or decreased a little bit, because again, workers that might have been working 48 hours per week were capped now at 40 hours. So I would not be surprised to see if it made minimal change, or if in general, given the amount of unmet need right now and the absolutely dire state of the workforce all over the country, if workers that were currently limited to 40 might be able to pick up more hours. I would not be surprised to see if wages actually increased a bit. Again, on a national level, what this means in a state really depends on that state's policy. So it could vary quite a bit at the state level.
Thank you, Kate. No more questions for now. Yep, none coming through.
Great. Well, thank you all so much for joining us today. We appreciate the great questions. Thanks for hanging with us. And again, if you'd like to talk with us one-on-one on this, we're having lots of conversations and are excited to have more. We know this changes, this can have a big impact on programs. So we'd love to connect with you if you'd like to talk more. Again, reach out anytime at membership@appliedselfdirection.com, and stay tuned for more updates. We will be updating you as soon as we learn more from the Department of Labor. And my final plug, to please submit comments if you're a participant, if you're a worker, if you're a family member. Absolutely, DOL needs to hear from you. And we will be sending out comments as well that you're welcome to use as a basis, or you're welcome to submit your own. So thank you all so much for joining us, and we will talk to you very soon.